As Elie Mystal writes, the biggest judicial power grab since 1803 in a decision that was just handed down is actually more important of a story than the limited victory the Supreme Court also handed on Friday to white domestic terrorists. Elie Mystal says it's going to be hard to get people to understand why, but if you're in the press, you have to at least try. We'll do more than just try here. We're joined by Mike Sachs, Senior Advisor to Court Accountability, and now an analyst here on the MeidasTouch Network on all things law and politics and all things with the Supreme Court. And what Elie Mystal is referring to is not the Fisher decision, which will potentially overturn hundreds of obstruction of official proceeding charges against domestic terrorists who attacked the Capitol on January 6th, but the decision overruling 40 years of precedent in the Chevron case and Chevron deference. This strikes an atomic bomb blow to the Administrative Procedures Act. If you studied administrative law, may as well burn your textbooks and throw it out the window. It just doesn't really exist anymore. Tell us about this case, its import, and the ripple effects that it's going to have.
Yeah, this case called Loper Bright with a companion case called Relentless was a 6-3 decision by the Supreme Court's Republican-appointed right-wing supermajority, grabbing power for themselves to say that they are now the sole arbiters of whether a presidency and executive can regulate matters of health and safety, financial regulation, any industrial regulation. It's now the Supreme Court's job, not the job of policy experts that are at the EPA, the FTC, the SEC, the FCC, you name it. If there's an issue in which Congress has said, you guys clean our water, make sure our broadband is good, make sure our air is good, make sure that people who are trying to be security fraudsters aren't being security fraudsters. If Congress has said that, but something comes up that kind of falls through the cracks, it's not quite clear whether Congress has regulated it, but it seems as though Congress has for 40 years, and arguably more than that. The people in those agencies can make a regulation, regulating or deregulating those matters based on the policy views of the administration in power, whether it's Republican or Democrat. Today, the court said no, doesn't matter whether they're experts. We, the Supreme Court, and the judges beneath us should be the ones who are going to decide whether you can regulate polymers and AI and any other very niche policy thing that experts, civil servants in these agencies have long been empowered to do. This sounds wonky, but it is a seismic shift in how our government works. And it is the result of a 40-year campaign, which has gotten increasingly intense since the Obama era, by right-wing dark money interests funded by Koch brothers and Leonard Leo and his web of corporate interests to capture the judiciary and to arrogate the power among right-wing judges, to pretty much effectuate a policy that says only Republicans can deregulate and Democrats are not allowed to regulate at all. That's what this comes down to. Now, the Chevron case we keep talking about, Chevron deference, was a 1984 decision that was championed by none other than Justice Antonin Scalia as he joined the court. Because that decision deferred to Ronald Reagan's administration's deregulatory efforts when it comes to things that regulate Chevron, big oil. And the Supreme Court, in a lopsided majority, said, that's fine. If Congress hasn't directly spoken to whether you can regulate or deregulate this particular issue, go ahead, you can deregulate. There's a fly going around here too. And that was the law of the land until the Koch brothers started flexing their muscle during the Obama years and said, we don't like this thing where you can regulate or deregulate based on what the agency says and courts deferring to the agency. No, we want to have a court and we want to have a regime that only allows deregulation, doesn't allow regulation of industry, doesn't cramp our profits. And today, by a 6-3 vote, Republican appointed justices over the Democratic appointed justices effectuated that regime.
So the way to think about it is Congress, though, when it passes laws, it doesn't delineate every specific role that an agency is supposed to engage in, right? I mean, when it sets forth the rules and obligations and responsibilities of what the EPA does or what the SEC does or what the FTC does, you name the agency, they're given these powers, and then the agencies take these powers and then they interpret them, and then they kind of have their own sets of rules about how they enforce them. Are they, to your point, are they more robust in a regulatory scheme? Are they less robust? How do they enforce this? How do they enforce that? And normally what the courts would say is, look, these administrative agencies have levels of expertise and we should give them deference. We as the courts are not experts in AI or this nuanced area of the environment or this specific SEC regulation. So what we call Chevron deference is the court, and correct me if I'm wrong with any of this, just saying, look, we'll defer to the agency's interpretation of their enabling statutes to allow them to do the function that Congress generally provided them.
Yeah.
And that's the way agencies work. And now what the Supreme Court is saying is, nope, we're not letting you do that anymore. So really, unless Congress really sets forth the most specific possible language that exists, we, the court, are going to basically say what it is that you do. And if you do things, we're basically going to strike down everything that you do where you exercise any degree of kind of discretion.
Yeah. And this is something we have to understand the two ends of the telescope the court's looking through here. The majority says they're acting to vindicate democracy from unelected bureaucrats who just work their own policy will on the American public. And what the court is doing is not taking power for itself to say whether those guys are doing things right or wrong, but rather returning power to Congress so that Congress can then pass laws to regulate as they see fit. But what's really going on is Congress already passed those laws. Congress already said, we want clean air. We want clean air in these parameters. Now, the EPA, figure it out, give us ways and fill in the gaps of this law with your regulations. As our technology evolves, as our understanding of things evolve, go for it. And courts can step in when things are arbitrary and capricious, or when an agency is acting clearly beyond and unreasonably beyond its statutory scope. That's been the regime. And otherwise, the agency can issue its regulation in ways that are reasonable if there's an ambiguity of whether Congress said you can do this. That's been how it's gone, but the right-wing majority today says that itself is unaccountable, and we need to let Congress, which it knows Congress will not do, make very specific laws as things evolve. And that's just not how these agencies, not how these statutes were designed. It's not how Congress works either. So in effect, as the dissenters say, this is a power grab. This is the supermajority of the Supreme Court knowing that when it takes this power from the agencies, which, mind you, are accountable to the public because they respond to the president, and the president, guess what, is elected. And when when administrations shift because the people want to change policies, then the policies of the agency shift as well. So it's not like these are unelected bureaucrats. These are people who are effectuating the policy of an elected administration. And now this court has said, doesn't matter if you're experts, doesn't matter if you reflect the policy choices of the American people, you're going to respond, you're going to report to us and our policy preferences of the truly unelected servants, if you can even call them that, of the public, if not the right-wing benefactors who put them on the court.
And as you mentioned, there was a role for federal courts and the Court of Appeal all the way up to the Supreme Court when Chevron was the law of the land. If an agency acted, as you mentioned, arbitrary or capriciously outside of the bounds of their enabling statute, there would be lawsuits. And we talk about a lot of these lawsuits all the time that work their way up the courts, and there are injunctions, and whether or not the agency can or can act. Did the agency go through the proper rulemaking process? Did the agency accurately interpret the enabling statute, or did they just go completely outside of the bounds? So that existed. There was a role for review by the federal courts, but now it's like in the first instance, you as an agency have really no power to do anything at all unless you can directly point to these magic words. You have zero power. There's nothing you can do. And it's the role of the courts now to tell you what to do.
And this is part of a multi-pronged, grand-scale ideological attack on what the right wing calls the administrative state and their attempt to deconstruct the administrative state, I think in Steve Bannon's words. So what's going on here is this. The court has already created a doctrine called the major questions doctrine, in which if an administration wants to regulate on a matter of great economic or social or political importance, say the regulation of greenhouse gases, or say relieving student loan debt, and they find a clear statutory hook, a clear part of a law that says that this agency can do that. The Secretary of Education can relieve student debts under the HEROES Act of 2003 or what have you. Then when that regulation gets put into effect, the Supreme Court says, no, that was a major question. And it doesn't matter if there's clear statutory authority for this for you to act, agency. Nope, it's a major question. We don't like that policy. So we're going to say you can't do this unless Congress passes a new law about this major thing. And then maybe you can act. I'll get to why about the other shoe to drop in a second. Chevron handles every little thing. Not the major questions, but the daily, quotidian questions. This case was about fish, I think, the Loper-Bright case. It wasn't about something huge. But from this little regulation came this massive bomb of a case that will now usurp the power, usurp the authority, usurp the policy preferences of civil servants acting out the policy preferences of administrations, elected administrations, and brings that to the Supreme Court again to say no, what we think, which is largely what our right-wing benefactors want us to think and want us to say. This is what goes, not what the elected officials' policy says about these every little thing. And that's two things. But there's one more shoe that might be dropping. And before the Supreme Court now, we could find out in the coming days whether they're going to take this case. And this is whether Congress can even delegate any authority to clean air and water and making sure our broadband is okay, and making sure the Federal Trade Commission can block mergers and acquisitions or what have you that are monopolistic. This is something called the non-delegation doctrine. We might be hearing more of this. This was something that was last used in the 1930s to help blow up the New Deal. And the court is now being asked by Don McGahn, former President Trump's White House counsel, who was the main leader in putting all these judges on the bench that reflect the same view, to deconstruct the administrative state. Don McGahn is bringing a case to bring back the non-delegation doctrine, to pretty much kill the occupational safety and health, OSHA, to kill OSHA, to kill the FTC, to kill the FCC, to kill the EPA, by saying that even if you delegate it, even if you say there's a major question and you clearly say so, you can make rules on this. Even if Congress says that, then that's still not allowed, because Congress can't be given that power to an agency anyway. It's too legislative, and Congress has to serve actually as the rule maker on every little thing, instead of letting agencies which make the rules do that. So this is a three-pronged assault. We've had the two already happen. They don't need to do the third to really fully blow up the administrative state. But if the court wants to really drop the huge nuclear bomb, that's waiting for them. And so it's an attempt not only to cripple the administrative state when it works towards regulation as opposed to deregulation, but now there's also an effort to make sure that when Republicans are in power, civil servants are actually purely political servants, not career experts. And they want to make sure that they want to also have an effort through Project 2025 and through other cases coming forward up to the court to make sure that the president can make any independent agency, and that includes the Fed and the FTC, fully dependent on the whims and wishes of a president that wants to take a wrecking ball to health, safety regulations, financial regulations, all of this. So it's a multi-pronged effort, a broad effort, pretty much to either bring the administrative state to its knees under Democrats, or to have it fully an arm of the Republican Party when it's under Republicans.
That's why people rightfully should be very concerned, and we should be talking as much as possible about Project 2025. But Project 2025 isn't something that's in the future. It's actually, to you, as you mentioned, it's already been a 40, 50-year project that's been taking place. And the Supreme Court, as it's moved more right, and as these right-wing Supreme Court justices have been able to implement this vision, it's really exemplified in decisions like the overturning of Chevron, and other decisions totally dismantling just the ability for there to be a functioning federal government, with ultimately the beneficiaries being corporations and wealthy people who don't want any regulation at all, so they can do whatever it is that they want and buy off whoever it is that they want. And it's a sad thing to see that here in the United States, but I think it's important that we here communicate what's going on with the appropriate details, so people get not just what the ruling is, but what the plan is. You and I are going to be doing a bunch more hot takes this weekend, so everybody make sure you check in. Mike Sachs, of course, senior advisor to court accountability. We're lucky to have him here at the MeidasTouch network as well, where he will be a continuing correspondent here on all things law and politics and the Supreme Court. Thanks, Mike.
Thanks, man.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.